So consequences of non-registration of charges faced by the company because company not registered their charges, not keeping their registered charges, and it is void. It creates the transaction which company enters into with the banks or financial institution. It is declared void because it is not recorded in the books of account. It is not keeping records. There is no record in register of charges. There is no registration of charges with the register of companies. Then in that case, it is declared void by the court of law, and you can make it void against the liquidator. Means liquidator in the case of winding up of the company, or liquidation of the company, or dissolution of the company. Company can ignore the charge and can treat the concerned creditor, concerned bank, or financial institution as unsecured creditors. So company can utilize that property or assets of the company for the use of the company for the company interest, and it is not utilized for the interest of the bank or financial institutions. So it is declared void in the court of law because of non-registration of charges of the company. It is not recorded. It is not registered with the registrar of companies. There is no proper record of any charges created with the asset. It's not in record. So how can you make that person liable, responsible for the payment of your dues? So that property can be utilized for the interest of the company, for the payment of loans of the company, for other purposes of the company. Uh, so property will be treated as free of charge. There is no charge over the assets of the company, and the creditors cannot sell property to recover its dues. So it is void against the creditor of the company means that if any subsequent charge is created on the same property and the earlier charge is not registered, it means that you have no consequences, and later charge if registered you enjoy priority. So the charge holder can have the property sold in order to recover its money. The charge holder is the bank. So bank can sold the property of the company, the assets of the company, the undertakings of the company for the purposes of securing their amount payment from the company if the charge is registered with the registrar of companies. Otherwise, uh, would have no consequences, have to be the consequences of non-registration of the company. Then come to the consequences of non-registration of charges, continuation of the same topic. Does non-filling of particulars or charge does not invalidate the charge against the company as a going concern. So the companies, this is a condition, the company going against the concept of going concern. In that case, the company has to bear the consequences of non-filling of particular charges, but it does not invalidate the charge against the company as a going concern. So it is void only against liquidator and liquidators at the time of liquidation. So, and the company itself cannot have a cause of action arising out of non-registration. So, so non-filling of particular charge does not invalidate the charge against the company as a going concern. Meaning is that you are liable for the payment of dues to the bank in the case of non-filling of particulars of charge. Does not invalidate the charge against the company as a going concern. It is void only against the liquidators at the time of liquidation, and the company itself cannot have a cause of action arising out of non-registration. Then come to the term inspection of charges, inspection of register of charges, inspection of instrument of charges shall be kept open for inspection during business hours of the company, during office hours of the company, by members, inspection by members, by creditors of the company, or any other person, or any investors of the company, any financiers of the company, prospective investors of the company, prospective shareholders of the company, uh, subject to reasonable restrictions as the company may by its impose by its articles association of the company. There are certain restrictions you can impose through or by your articles for the purposes of inspection investigations of the register of charges of the company or instrument charges of the company by having a clause, added clause in the article section of the company for the purpose of giving restrictions to the company for the purpose of investigations or inspections by the members of the company, by the shareholders of the company, by the creditors of the company. Or, it can be opened by the bankers of the company. It can be opened for inspections on demand by these persons on payment of nominal fees by this person. So it can be during business hours by members of the company, by creditors of the company, or any other person subject to reasonable restrictions or as the company makes impose by its AOE. So the register charges and instrument charges kept by the company shall be open for inspection. Uh, Number one point in this, A point in this, by any member or creditors of the company without fees and by any other person on payment of fees. That is the criteria for the purposes of inspections or investigations of the books of account of the company, important documents of the company, important books of the company, ledger books of the company, transactions of the company. And in this case, without fees, and in the case of other persons, by payment of nominal fees to the company, can inspect their books of accounts and register of charges of the company. Then come to the penalty for contravention. This is penalty imposed on the contravention of the provisions of Section 86, Section 1 of the Companies Act 2013. The company is in default in complying with any provisions of this chapter. The company shall be liable to a penalty of rupees 5 lakh. So, penalty for contraventions, non-compliance of the provisions, non-following of the provisions of the Companies Act 2013, Section 86, Section 1, and the officers who are involved in default in complying with the following of the provisions mentioned in the Companies Act in respect of the keeping records of registration of charges and keeping register of charges. In that case, the person concerned and person involved, whosoever involved as officer of the company, as director of the company, those are involved in that particular fault on their part, shall be liable to a penalty of rupees 5 lakh, and every officer in default shall be liable to a penalty of rupees 50,000. Any person willfully punishes any false, incorrect information or knowingly suppresses any material information which is required to be registered under Section 77 of the Companies Act 2013. Meaning is that if any person, by his or her wish, uh, providing any false information, incorrect information, and knowingly suppresses, knowingly, intentionally hiding material information, important information of the company. So any person means any person of the company, any officer of the company, whether by company secretary of the company, chartered accountants of the company, directors of the company, members of the company, shareholders of the company. Any person willfully punishes any false, incorrect information or intentionally, knowingly suppresses, hiding uh, any material information about the company which is required to be registered under Section 77 of the Act shall be liable for action under Section 447 of the Companies Act 2013. Punishment for fraud, punishment for fudging of accounts, punishment for not keeping books of accounts, not keeping register of charges, as per liable under the section 447 of the Companies Act 2013. These are the penalty provisions for the contraventions as per the Companies Act 2013, section 86, section 1. There's a default. If any person is a default in complying with the provisions of this act, shall be liable to pay payment of the penalty of rupees 5 lakh, and the officers who are in default in non-payment of their dues, default in uh, preparation of making of registered charges, shall be liable to a penalty of rupees 50,000. And any person by this line meaning is that any person means that any person of the company, whether company secretary by its nature, cost accountant by nature, chartered accountant by nature, any legal advisor by nature, any directors of the company, members of the company, shareholders of the company, investors of the company, any person knowingly, intentionally hiding, suppressing important information of the company as required to be disclosed by the company under Section 77 of the Companies Act 2013 and liable under Section 447. Punishment for fraud is there. Punishment for fraud is there for the officers of the company who are liable for the payment of the dues. Then conclusion, the conclusion of this particular session class, this particular topic. The Companies Act 2013 lays down specific guidelines for registration and modification and satisfaction of charges, reflecting its significance in the corporate lending scenario. This is very important topic of discussion, registration of charges, modification of charges, satisfaction of charges, and it's important in the corporate world. And understanding these guidelines as per the Companies Act for the purposes of keeping record, register of charges, duties to register of charges, duty to maintain register of charges, and consequences of disclosure of the register of charges, not mentioning of register of charges for both companies and lenders to ensure compliance and to ensure legal validity of the that particular charge created over the assets of the company. So this process brings transparency and safeguard the interests of all parties involved, forming an essential aspect of corporate financial management, and therefore adherence to these provisions is not merely a legal formality, but a vital practice for robust financial governance. This process brings transparency and safeguard the interests of all parties involved, forming an essential aspect of corporate financial management, and must be adhered to the provisions of the Companies Act for the purpose of giving validity to the legality to the charges created over the assets of the company. And it is required for the purposes of financial governance, corporate governance. It is required to uh, keeping maintaining records of register of charges, registration of charges, mortgage we are studying today, and the difference between charges and mortgage we are studying today. Registration of charges we are discussing today. In detail we are discussing today. The legality of registration of charges and procedure for involved in registration of charges and consequences of non-registration of charges and again inspection of charges, penalty for contraventions of non-registration of charges or not keeping register of charges, then concluding remarks. So by this I am unable to take class. Thank you all for having patience and listening. Thank you.